Good evening, y'all. Once again, I'm back with another video, and I'm your host, the Supreme Litigant. Before I begin, y'all already know the routine. Go ahead and hit that like button and that subscribe button ASAP. And I'll give y'all a second to do that. All right, let's just jump right into this. In this video, what I'm going to be talking about is equitable estoppel. Equitable estoppel is an affirmative defense of the jurisdiction of equity. It's an affirmative defense that was asserted in a court of equity or a court of chancery, so to speak. And you can use this in a federal lawsuit. I've seen this asserted as an affirmative defense in a federal lawsuit, which is more proof that, like I've told y'all, they have merged all of these rules of procedure into one court, so-called court. And they didn't just do that with common law and equity. They did it with maritime and admiralty too. So, for example, the Federal Rules of Civil Procedure governs cases at law in equity, maritime, and admiralty. And the Alabama Rules of Civil Procedure does the same thing. So I want to explain this to y'all a little bit because I if I'm not mistaken, I've heard U.C.C mention something like this on his channel. He was talking about when you send notarized affidavits or something like that to whoever it is you have an issue with and you're trying to resolve, and you get this notarized and you got proof that it's notarized, you can get this evidence admitted into court and use it against them so they can't come back and claim some type of defense or something like that because you were trying to resolve the issue and they never responded back to you or something like that. But let me go ahead and jump right into this. Before I do it, I'm gonna give y'all this. Well, I'll give y'all the case citation after I read y'all this. The basic elements of equitable estoppel are stated in Dobbs Remedies, Section 2.3, 1973. An estoppel has three important elements. The actor, who usually must have knowledge of the true facts, communicates something in a misleading way, either by words, conduct, or silence. The other relies upon that communication, and the other would be harmed materially if the actor is later permitted to assert any claim inconsistent with his earlier conduct. A more detailed statement of the three elements generally required to support an estoppel is given in 3 Palmery Equity Jurisprudence, Section 805, 5th edition, 1941. There must be conduct, acts, language, or silence amounting to a representation or a concealment of material facts. These facts must be known to the parties estopped at the time of his said conduct, or at least the circumstances must be such that knowledge of them is necessarily imputed to him. The truth concerning these facts must be unknown to the other party claiming the benefit of the estoppel at the time when such conduct was done and at the time when it was acted upon by him. Let's go down a little bit more. The conduct must be done with the intention, or at least with the expectation, that it will be acted upon by the other party, or under the circumstances that it is both natural and probable that it would be so acted upon. The conduct must be relied upon by the other party, and thus relying, he must be led to act upon it. 6. He must in fact act upon it in such a manner as to change his position for the worse. In other words, he must so act that he would suffer a loss if he were compelled to surrender or forego or alter what he has done by reason of the first party being permitted to repudiate his conduct and to assert rights inconsistent with it. It says this language is quoted with approval from Palmery's 4th edition in Jacksonville versus Public Services Calhoun Water Corporation. This is in 1929. So I want y'all to notice these cases that I'm giving y'all when they're talking about equity. there before the courts merge cases. I mean, when they merge the rules of procedure at the rules of procedure for a court of law and a court of equity and admiralty and maritime. These cases are before that. Let's see. There's another one in here too. Let me see if I can find it. Here's another one right here. Equitable estoppel, based upon the ground of public policy and good faith, and is interposed to prevent injustices as to guard against fraud by denying to a person the right to repudiate his acts, admissions, or representations when they had been relied upon by persons to whom they were directed and whose conduct they were intended to and did influence. The doctrine of estoppel is far-reaching in its effect, extending to real as well as personal estate and embracing almost every enterprise in which men may be engaged. Okay, so that tells you right there that this affirmative defense of equitable estoppel is applicable to a lot of circumstances. I think we'll stop right there. That's only one affirmative defense of equity. There's another one. I forgot what it was. There's actually, I don't know how many. I don't know how many there are, but I'm going to study and I'm going to find out. But I just wanted y'all to know that I thought that was pretty interesting. So I just wanted y'all to know that if this makes sense to you, if you know if you ever heard Yusuf say something about this, comment it below, because I remember him saying something very, very similar to this on how you can use a notary against these people. I forgot what he said, but anyway, that will be the end of this video. I hope y'all learned something. But before I go, let me give y'all this case citation. This is the case citation right here. That's the case citation right there. Anyway, I hope y'all learned something. The Supreme Litigant is out. Peace.